Hi, I'm Greg Dell, and this is attorney Stephen Jessup, and today we're going to talk about Cigna long-term disability insurance benefit denials and lawsuits. Specifically, we're going to focus on the aspect of making the assumption that someone's either has completed all of their appeals for a Cigna matter and now they have to file a lawsuit. And the roadmap we're going to follow is what are the first steps to take when filing a lawsuit, and then talk about what expectations should be during a lawsuit, and then we'll talk about the possible remedies for a Cigna lawsuit and our experience in handling the hundreds of claims we have across the country against Cigna for lawsuits. So the first thing is you have this denial letter. It says you've exhausted all your remedies. ERISA says you can file a lawsuit. What actually has to happen now?
First and foremost, you really need the claim file. You get your final claim file. Will have all the information through the appeal process, all the medical reviews, all of the information that you submitted. Having the claim file is going to be the first step. Now, after a lawsuit's filed, Cigna is going to have a duty to give that to you, but that could be much later down the road. So it's easiest just to get it from the beginning so you can break it down, analyze it, and we really then have the ability to assess chances of success, issues with the claim, and have a very open, realistic dialogue with the client as to how they can expect this is going to go, how long it may take, and what the possible outcomes, like you said, will be.
Okay, so once we file a lawsuit, we go ahead and put it in any federal court across the country, basically based upon where we think we can have the best chance for the client. It can be in any court, and like I said, we can help you anywhere in the country because we can file in any federal court. A lot of inexperienced lawyers try to put it in state court. That should be your first clue that you're talking to a lawyer who doesn't know what he's doing, because if it's governed by ERISA, you can't go in a state court, period, end of story. What are the time frames from a lawsuit to a judge issuing a scheduling order, and then possible, if it has to go to summary judgment motion, to getting a verdict from a judge?
That's another interesting thing depending on the federal court. I mean, inside a particular federal court, you can, even based on the judge you get, can dictate what those time frames can be. Sometimes judges are giving you 6 months, sometimes they're giving you almost 2 years. So if we just use the law of averages, after the lawsuit's filed, it's going to be served, and then Cigna is going to have 21 days to answer it. Usually there's somewhat of a short extension there, but I'd say within a month you're going to get your answer back from Cigna, and that's their basic, their formal document, basically denying everything you said in your complaint. Shortly thereafter, you have to work with the attorney to set a scheduling order based on what the judge wants. But typically, I would say within the first 45 to 60 days after the lawsuit's filed, you're going to have an idea when the judge is going to want mediation, when motions are going to have to be ready, when you're going to have your trial period, if the judge is going to give you a hearing on your motions, and then from there. But realistically, I think it's safe to tell a client that after a lawsuit's filed, if it goes through the entire trial process and motions are argued, it may take up to 18 months.
Okay. Let's talk about, we said 18 months if it's going to go through a trial and get an opinion from a judge. The reality is that 98% of these cases don't go that route.
Correct.
So if I'm a claimant looking at this going, when am I going to see some money? That's what I'm thinking about. I already probably have not been paid in a year because I had a 90 or 180 day elimination period to even qualify for long-term disability. Then I probably got denied early on in the claim, or whenever it may have been. If it was an initial claim, then you were getting paid for a while and then you got denied, but you had 180 days to do an appeal, and then they had 45 days to review, and the likelihood is that they took 1 or 2 extensions to review your appeal. So here we are, 9 months to a year, you haven't been paid at all, there's no money coming in, it's a huge financial problem. Our job when we get retained is how quickly can we get the benefits reinstated, or how quickly can we get to some kind of negotiated settlement to get this matter resolved. Through us handling probably, I've lost track of the numbers, but obviously it's hundreds, if not over 1,000 lawsuits we filed against Cigna across the country. Cigna knows already what we can do and what's going to happen if they want to go toe-to-toe. Clients get the benefit of that. The reason they get the benefit of it is that they know already when dealing with attorneys Dell and Schaefer that we know what we're doing, and they're going to end up paying their Cigna lawyers tens of thousands of dollars to defend a lawsuit if they want to go that route. So clients get the benefit to possibly get either an early on negotiated settlement or a negotiated settlement without tons and tons of litigation going on because of the fact that we've done that already. So In terms of reaching a settlement, why is it that 95, 96% of these cases resolve in a lump sum settlement, in your opinion?
Well, I think touching upon what you said is a lot of times people, unfortunately, when you're not getting paid, sometimes they're in real dire needs of money. So that's a big reason and an incentive to try to start early. But the real reason why the vast majority of ERISA-based claims are going to settle is the standard review in the law. In court, it's unfortunate, it's very unfair for you. You don't testify, your doctors don't testify. You're not going to have a jury. The federal judge is going to review the information that's in that claim file only. So if you had new information that came about after that final denial, that's not allowed for a judge to consider. And that judge is going to determine two things. One, do they think you're disabled? If yes, it comes down to, did Cigna have a reasonable basis to deny the claim? So the law is really set up in Cigna's favor. And even some years ago, a couple years ago now, when they were fined by a handful of states for their claims handling practices on disability claims, Cigna entered into a settlement agreement with various state insurance commissioners. And in my opinion, what was supposed to be meant to help insureds get a fair shake gave Cigna a beautiful roadmap of what the states thought that should be done in reviewing a claim to make it a fair review. So now when you see a Cigna denial letter, you can almost see the boxes being checked off. And then they end up in court and they say, you know, we've been punished. We know we've been bad in the past. We've learned from our mistakes, and look at all these things we've done. They've just basically strengthened their already, high chances of winning. So with that in mind, that's the reason why a vast majority of these cases will settle. And some people think, well, if they're going to win the case, why would they even want to? And there's various reasons for that. Like you said, they're paying their attorneys, their outside counsel by the hour. There's having to do with what the government says they have to keep in reserve. So there's money that they can't spend. So if they buy you out, they offer you a settlement's accepted, they can take that money out of reserves and reinvest. So there's an incentive for Cigna to do it as well, just as much as there is for the client. And from my experience, Cigna is one of the insurance companies that I've been able to get them to come to the table even well before the mediation date. And mediation is where a court's going to order a formal sit down between all the parties to try to negotiate a settlement.
Right, and the reality is that if you have a case that's worth 200 grand and they offer you 75 or 100 grand, it's a pure financial decision at that point, because are you going to spend 75 or 100 to try to get 200? That's really the same as you might as well go to the casino, take your 75 or 100, bet it on black. If you win, you double your money. If you lose everything. And I'm really minimizing it here, but you're going to have a little bit more data going into the court, but it's going to come down to one judge's decision, and that's it. You could, of course, appeal that again to a federal court if you lose, but now you're talking about 3 years of time to go from start to finish, and that's a long road, to possibly go.
And to that point too, is you make the analogy of putting it all on black or putting it all red. That's a 50-50 chance. Statistically, you don't have a 50-50 chance in ERISA litigation because of that standard of review. So it's a bigger risk taking it all the way, because if it's unfavorable, there's zero as compared to that guaranteed money that may be negotiated.
Right, and I want people to get the flavor of our law firm, that we're going to be super practical. I set aside our trial egos. I love to go to trial and get a verdict against them, and often, I'm not going to say we're going to push the client to go to trial. There's a lot of law firms who want the clients to settle because they think it's a guaranteed money. We want what's best in your best interest going forward. So that's important that you're dealing with a law firm who's, if you say, I don't want the money, I'm going to go, we're going to tell you what we think the risks are, what chance you have, but whatever you want to do is you are the captain of the ship, you make the decision, and we're here to get you into the best possible position to get your benefits. The last thing is the remedies. At a lawsuit, I'll just go through those quickly because we have a general video about that you can watch and what to expect in an ERISA lawsuit. But a lot of people don't realize that if you do win the lawsuit, what you're winning is your back benefits. Correct. You don't win the next 10 years that you're owed of benefits plus your back benefits. You just win those back benefits. You go back on claim. And if we win the case on Friday, Monday morning, Cigna can reevaluate you, send you to a doctor who says, we think you're better now, and now you got to do the whole thing over again. So a lot of people like to resolve a claim because they want to be done with Cigna. They can't stand them. They want to get X amount of years of benefits, try to move on with their life if they can, and just be done. And that is one advantage of the finality of a lawsuit versus going through, possibly winning. Maybe they appeal, maybe they cut you off down the road. Either way, we're going to have your back the whole time. If they put you on claim, or if you win and we got to keep you on claim, we're going to do everything we can. So the steps are, if you've been denied by Cigna, go ahead and click the free consultation button on our website or call us right away. A lawyer is going to immediately respond to your phone call or email. We need a copy of your final denial letter. We will review it right away. We'll let you know immediately if we can help you. We never charge fees or costs for us to represent you unless we make a recovery. And that's really important because you don't want to come out of pocket with tens of thousands of dollars to try to possibly get a recovery in your claim. So we become a partner in your claim, and we're going to push to get every single dollar we can to get you the best return possible. So thank you for considering us, and we look forward to the opportunity to speak with you.